Welcome to the Deep Dive. Today we're looking at a really specific Supreme Court case involving a Texas death row inmate, Ruben Gutierrez. But trust me, the implications here are huge.
You really are.
This deep dive is basically your shortcut to understanding a core legal puzzle. When can someone in state prison sue a state official, like a prosecutor, in federal court to get access to evidence?
Exactly. We're talking about Gutierrez v. Saenz, decided just this past June 2025. And like you said, it's not really about guilt or innocence in the way you might think. It's all about the procedure, the legal hoops. The big question for you, the listener, is about this federal civil rights law, Section 1983, and when it lets a prisoner demand DNA testing from a state prosecutor in federal court.
Right, and it hinges on this concept called standing.
Yeah.
So our mission today is to unpack Gutierrez's, 15-year battle, explain procedural due process in this context, and show why this ruling is such a big deal for how federal courts oversee state procedures.
Okay, so let's set the scene. The background is, frankly, tragic. 1998, Brownsville, Texas. Ruben Gutierrez is convicted of capital murder.
The victim was an elderly woman, right?
Yes, 85-year-old Escholastica Harrison. She was killed during a robbery that Gutierrez was involved in planning. The state's case was that he, along with another person, stabbed her multiple times with screwdrivers. Horrific details.
So, capital murder conviction. But the way Texas law works here is crucial, especially for the death penalty part. It's not straightforward.
Not at all, and that's really where this whole legal fight starts. See, under Texas law, Gutierrez could be convicted of capital murder just for being a party to the crime.
Meaning he was part of the robbery that led to her death, even if he wasn't, say, the main attacker.
Precisely. You could be guilty of capital murder in Texas if you're involved in the underlying felony, the robbery here, and someone dies as a result.
Okay, got it. Guilty of the crime itself because he was an accomplice, but then there's the death sentence. That requires something more, doesn't it?
Absolutely. A death sentence in Texas needs a higher level of culpability. The jury has to find specifically that the defendant either actually caused the death or intended to kill or, and this is important, anticipated that a human life would be taken.
Okay, and those are the innocence standards from previous Supreme Court cases.
That's right, those standards. And in Gutierrez's case, the jury answered yes to that sentencing question. They found he met that higher bar, played a major role, showed reckless indifference to human life.
And Gutierrez has been fighting that finding for, well, almost 2 decades now. His argument is that he didn't meet that standard. He thinks DNA testing could prove it.
Right. He wants to test things like fingernail scrapings from the victim, a loose hair found at the scene, blood samples, evidence he believes could show maybe he wasn't the stabber or maybe he wasn't even in the house.
So why couldn't he just get the testing done? Texas must have a process for this.
It does. That's the frustrating part. Texas has a law, Article 64, specifically for post-conviction DNA testing, but there's a catch.
Always a catch.
To get testing under Article 64, the prisoner has to show by a preponderance of the evidence, so more likely than not that they would not have been convicted if exculpatory results had been obtained.
Okay, that sounds like a high bar, but maybe logical. You have to show that DNA could prove innocence.
It sounds logical, but here's how the Texas Court of Criminal Appeals, the TCCA, interpreted it. Gutierrez asked for testing, multiple times, 2010, 2019. Denied every single time.
And the TCCA's reasoning was?
Their reasoning was, look, even if new DNA tests showed Gutierrez's DNA wasn't on the screwdrivers or under the victim's nails, he'd still be guilty of capital murder.
Because of the party liability thing.
Yeah.
Because he was part of the robbery.
Exactly. So they said the DNA results wouldn't prove his innocence of the underlying crime of capital murder.
Wow. So they basically said Article 64 can only be used to prove you're totally innocent of the whole crime. Not just that you were wrongly sentenced to death because you didn't have the required intent or role.
Yeah. That's precisely the trap. The TCCA explicitly ruled Article 64 could not be used just to challenge the death sentence eligibility. They said the facts already on record showed he met the innocence culpability standard anyway.
So Texas gives this theoretical path to challenge the death sentence. But then the state's highest criminal court interprets the DNA law in a way that makes it impossible for someone like Gutierrez to use it for that specific purpose. Sort of an illusory right.
Illusory is a good word for it. He kept hitting this brick wall in the state system.
Which naturally pushes him towards the federal courts.
Right. So he files a federal lawsuit. He uses that federal civil rights law we mentioned, 42 U.S.C. Section 1983, suing the local district attorney, Saenz.
And his argument is basically that Texas's whole setup violates his constitutional right to procedural due process. Like, the state created a right but made it impossible to actually access.
That's the core of his federal claim. But then you immediately run into the standing issue in federal court. It's like the first gate you have to pass through.
Right. Standing. You need injury, causation, and redressability. Let's break down redressability, because that's where things got sticky.
Okay, redressability. Think of it simply. If the court rules in your favor, will that ruling actually fix the problem you're complaining about?
So for Gutierrez, the injury is being denied access to the DNA evidence. The cause is the prosecutor refusing access based on that state law, Article 64. Redressability means a win in federal court has to be likely to fix that denial.
Correct. And the federal appeals court below the Supreme Court, the Fifth Circuit, looked at this and said, nope, no redressability here.
Why not? Why do they think a federal court ruling wouldn't likely fix the problem?
Well, they took a very, let's call it a practical approach. They said, essentially, look, the TCCA already shot down Gutierrez's requests for other reasons, too. Even if we say this specific part of the Texas procedure is unconstitutional, we don't think the prosecutor or the state courts will actually change their minds and allow the testing.
Huh. So they were kind of predicting the future, saying, our ruling probably won't make a difference in the end, so he doesn't have standing to even bring the case.
That's basically it. They thought the prosecutor was, quote, unlikely to reverse course. So no redressability, case dismissed.
Okay, this is where it gets really interesting legally, because the Supreme Court stepped in and said, hold on a minute, this sounds technical, but why should a federal court not just be practical like the Fifth Circuit suggested?
That's the million-dollar question the Supreme Court tackled. And if the Fifth Circuit's view held up, it would seriously limit when federal courts could review state procedures.
So what did the Supreme Court say?
They leaned heavily on a recent case, Reed v. Zagertz from 2023. They said the Fifth Circuit misunderstood the whole point of procedural due process claims.
How so?
The injury isn't ultimately not getting the evidence. The injury is being denied a fair process because the state is relying on a reason, a procedure that might be unconstitutional.
Okay, so the Supreme Court's job isn't to predict what the prosecutor does next. It's to decide if the reason the prosecutor gave today is based on a constitutional state procedure.
Exactly. They said redressability is met if the court's ruling eliminates that specific, allegedly unconstitutional justification the prosecutor used. Getting rid of that bad reason is fixing the procedural injury.
So it doesn't matter if the prosecutor says, well, I'll just find another reason later. The prisoner has the right to challenge this reason right now if it's potentially unconstitutional.
That's the principle. The Supreme Court actually pointed out two big errors in the Fifth Circuit's thinking.
What were they?
First, they said the Fifth Circuit looked too narrowly at the case. They only focused on the very specific, limited ruling the trial court eventually gave Gutierrez.
Instead of
looking at Gutierrez's original complaint, which challenged the whole structure of Article 64 as applied to people convicted as parties, basically arguing the whole system made testing virtually impossible for him. The challenge was broader.
Got it. Look at the whole challenge, not just the tiny piece that got through initially. And the second error.
The second, and maybe more fundamental error, was what we just discussed. The Fifth Circuit wrongly guessed about whether a favorable ruling would ultimately lead to testing. The Supreme Court slammed that door shut. They said you can't turn redressability into a guessing game about the final outcome.
This feels like a really important clarification, not just for death penalty cases, but anytime someone is fighting a government agency over process. If the agency uses a potentially invalid rule to deny you something, you have standing to challenge that rule.
Absolutely. It reaffirms the power of federal courts to police the process states offer. And the court also had to deal with a related argument the prosecutor made: mootness.
Mootness, meaning the case is pointless now.
Yeah, the prosecutor basically said, look, even after the lower federal court kind of ruled for Gutierrez, we still refuse testing. So this whole case is moot because we're telling you the outcome won't change.
How did the Supreme Court handle that?
They shot that down too. They used a helpful analogy. Imagine the government is supposed to do an environmental study before approving a dam.
Okay.
If citizens sue because the agency skipped the required study, the agency can't just say, well, we promised we'd approve the dam anyway, so your lawsuit is moot. The injury is the lack of the proper procedure, the study. Forcing the agency to follow the procedure is the redress.
So the prosecutor promising the end result stays the same doesn't kill the right to a fair process along the way.
Exactly right. You can't moot a procedural due process claim just by promising the substance won't change.
So, pulling this all together, what's the big takeaway here for the legal system and for Ruben Gutierrez himself?
Well, for the system, it's a clear signal. Federal courts can and should step in when state procedures seem to block access to fundamental rights, like challenging a conviction or sentence. States can't offer a right with one hand and then use, procedural sleight of hand, as the court put it, to make it impossible to exercise with the other.
And crucially, listeners should remember what this decision doesn't do. The Supreme Court didn't order Texas to give Gutierrez the DNA test.
Not at all. They didn't rule on whether Texas's Article 64 is actually unconstitutional or not. This was purely about standing the right to sue.
So Gutierrez now just gets to go back to the lower federal courts and argue his case on the merits. He gets his day in court on the constitutional question.
Precisely. He's won the right to make the argument. Whether he ultimately wins that argument and gets the testing is still undecided.
Now, our background reading mentions some pretty strong dissents in this case, particularly from Justices Alito and Thomas. They bring up a counter-argument about finality.
Yes, and it's a powerful tension. The dissenters essentially argue that these kinds of protracted procedural fights lasting decades undermine the whole point of having a justice system that reaches a conclusion.
Their view is that it just aids and abets, I think was the phrase, delays in carrying out lawful sentences, and that this harms the state's interest, and especially the victim's interest, in seeing a case finally resolved.
That's the core of the dissent. You have this clash. On one side, the need for rigorous constitutional review of procedures, especially when a life is at stake. On the other side, the need for legal finality, for judgments to actually mean something and not be endlessly relitigated.
So where do you draw the line between necessary federal oversight to ensure fairness and maybe unnecessary interference that just creates endless delay?
That is the fundamental conflict, isn't it? The Supreme Court drew the line in favor of oversight in this specific procedural context, but that larger balancing act, especially in capital cases, that's a debate that is absolutely not settled and will likely keep shaping American law for a long, long time.